Okay, good morning all. Lecture notes for today's class, I already uploaded on your visual website, on your UNIC visual for this topic and for the next topic, because we are going to cover both topics today. And I also have uploaded the assessment questions on the website yesterday night. Your slide I already uploaded in the evening, but your questions I only uploaded last night. And then if you realize that your class have been divided into two groups. One group is with me, 27 students, and another 25 students will be under Miss Fatin, another new lecturer. So for your assessment, you will do your assessment for students who are under Miss Fatin. You will do your assessment with her. So if you want to form assignment, it is group presentation. So for the group presentation, you have to form the groups according to who is teaching you for the tutorial. So for my class, I will only hold the presentation for the 27 students who are inside my student list. So another 25 students will do their presentation with Miss Fatin. Because if we want to do our presentation during class, we will not have enough time. So I will only do the presentation during our tutorial session in the evening. So those who are inside my group, 27 students who are inside under my name, you will form your groups among you all lah. So the other 25 students, you have to form your group under Miss Fatin. Okay, any question? Okay. So for the morning session, the lecture, all of the lectures will be with me. But I already confirmed with Puan Nadia, and she said that for students who are under the name of Miss Fatin, you are free to join my class in the morning, but it is not compulsory. But for the 27 students who are under my list, it is compulsory for you to attend the morning class as well as the evening class.
Miss? Miss?
Yes. Yes.
Miss, if okay,
Huh?
like how we can know that which lecture I'm supposed to attend, like Miss Fatin, or is it
Oh,
you?
does it not appear in your list? Because it appeared in my list. Wait, I'll share the list with you. So for BAWB 1013, these students are under my list. So Maheswari anak perempuan Salapan, Zahirul Haq and Zebo Dushatova. All these three students are under my list. Then for BAWB 1013, this student Pravin Kumar anak lelaki Ravi. You are under Miss Fatin Najla's class. So for tutorial, you have to join her class. This is for BAWB 1013 students. Then for BAWB 1014, these students are under my name. Amalia Aida binti Ahmad Nordin, Azida Hazlin binti Hayazi, Darshini anak perempuan Chandra Kasan, Darvina anak perempuan Chandra Kasan, Doneshwari anak perempuan Murugan, Dureshwari anak perempuan Jaya Krishnan, Desiman, Govin Raj, Hari Darshini, Lavinia, Marvin Raj, Nicholas Iskandar, Nur Shakila, Nur Wendy, Nurin Sabrina, Nurul Ain Akila, Nurul Ain, Aisara Aisyah, Revati, Sabrina, Saresh, Tinisha, Tivia, Usharani, Yashvini and Deshita. All these 27 students are inside my group.
So we can join morning class with
Ah,
Miss, but evening we have to join that our lecturer.
yes. So for these 27 students, you will be with me during the morning and the evening. But for the others, wait, I'll share the other list. So for this student, Mardia Abdul Hafiz, Fawaz Syahid, Kanaga Setupati, Kasturi Lishalini, Akif Farizi, Mohana Guri, Muhammad Abdul Hadi, Natasha Shazwani, Nurul Izzah, Previna Puguneswari, Putri Elia Fira, Shalini, Sharin Rose, Stephen, Swita Tarani, Tanisha, Utaya Sarvini, Vanisha, Vinosh, Wan Muhammad Firdaus and your guests. All these students for evening class, you have to join the class with Miss Fatin. Okay, so she already shared her link to class inside the your virtual website.
Ma'am.
Yes.
Okay, good morning. So,
Mhm.
in tutorial time is I'm with you, but I have here the link also. So, should I join there or here with you, ma'am? Because my name is Liz
For
with you actually.
so if your name is listed with me, both morning class and evening class, you have to join me.
Okay, awesome. Thank
Okay.
you.
Okay. So if your name is under Miss Fatin, for evening class, you have to join her class. So her
Okay.
class is also so for students who are under Miss Fatin's class, during evening class, you have to join this class using this link. Okay. So the other 27 students, you can join my class both morning and evening. Okay. So for assessment question, it will be the same both for students under my name and under Miss Fatin's name. Both are going to do the same assessment, but your assessment will be conducted by Miss Fatin and it will also be marked by her. So for the 27 students, your assessment will be conducted by me and it will be marked by me. Okay. So any question regarding the separation between students under my list and under Miss Fatin's list?
Yes, morning, madam.
Yes.
I assume this would affect for our assignments, right? That means we have to find if we want to make a group, we have to make within our own sections, right?
Yes. Alright.
Oh, okay. Thank you, madam.
Okay. Any other question? like what Saresh said, yes, your if you want to do your group presentation, you have to find the students who are inside the same section as you, because for because I will do the presentation during tutorial. So because in evening you are separated into two groups. So if you want to do your presentation, you have to do with people who are inside the same section with you. Okay. So if you don't have any other question, we will start with our lecture for today. So we will cover two topics today. Both topics are under the same main topic. So today, basically, what we are going to learn about. Sorry, actually, this is law of tort one. Okay. So for today, we are going to cover two topics. Both topics are under the same heading, which is law of tort. So for the first part of the lecture, we will learn about the functions of law of tort. So because when I asked last week, some of you does not haven't heard about tort before this, so you don't know, you don't have any idea what is tort. So in the beginning of the class, we will talk about what is tort, what is the law of tort, and the types of tort that we have. What are the different types of tort that we have? So it means that how. So it means that in what type of situation does the law of tort arise? But for your class, I will only be talking about one of the torts, which is tort of negligence. Actually, there are many torts exist, but we will only cover one of the torts in our course, which is tort of negligence. Okay, so start off for this topic, we will learn about what are the functions of law of tort. Why do we need law of tort when we have law of contract? We already have law of criminal law. Why do we have law of tort? What is the functions of law of tort? And we will also go deeper into what are the elements that need to be fulfilled in order to be liable for tort of negligence. So in law, if you want to get something, if you want to prove something, there are usually certain elements that need to be fulfilled. So there are certain criteria that you have to satisfy in order to get your compensation, or in order to get whatever you want under the law. So under the law, everything have their own elements that you have to fulfill. Everything have their own criteria, have their own conditions that you need to satisfy if you want to get something. So similarly, for tort of negligence, if you want to succeed in your in your claim for negligence, there are four elements that you need to fulfill in order to succeed in your claim. So I will be talking about all those four elements that need to be fulfilled in order to be liable for tort of negligence. So before we start on tort of negligence, we will talk in general about what is tort. So tort, it's actually came from French word. Tort in French, it means wrong. If I'm not mistaken, tort in French, it means wrong. So tort is a civil wrong. It is not a crime. Do you still remember last week when I differentiate between civil wrong and criminal wrong?
Yes, madam.
What is the difference between civil wrong and criminal wrong? What is the main difference?
Madam,
Yes.
may I try?
Yes, yes.
Civil wrong is something that is a wrongdoing in terms of civil matters, and it can. I was something about the court system. Sorry, madam, may I describe what is criminal law at least?
Yes.
Okay, criminal law is something that is punishable in an offense in the federal court, madam.
in the court. It's not
It
necessarily
carries a higher sentence. Maximum meaning that. Oh, okay. Sorry, man. Just so yeah. And also one thing, the criminal law has the highest sentence, meaning the death sentence.
Okay. So what is civil wrong?
Civil wrong. Sorry, madam. Is it most probably like the wrongdoings among society, like small matters in terms?
That is almost correct.
Sorry, madam. I guess that's all I got.
Yeah. So what Saresh is saying is almost correct, and we can add on what Shakila said. So when it is about civil wrong, usually it is about monetary compensation. So when someone commits a civil wrong, what you want is money. Sometimes it's not about money, but mostly it's usually about money. So usually when we talk about civil wrong, it is between two private parties, like what Sarish said. It's about between the societies. It doesn't have anything to do with the government. I mean, it doesn't have anything to do with the state. So it is between two normal people, two normal citizens in Malaysia. So it is usually about monetary compensation. About you want to get damages. Damages, like I said last week, damages is ganti rugi. So when you want to get damages, usually you sue someone under a civil wrong. But it is different with criminal wrong, because criminal wrong is something which is we call it an offense against the state. So you did something wrong against the state of Malaysia. What is going to happen to you is when you commit a crime, you will be punished. So punishment have several levels of punishment. The lowest punishment is fine, denda, and it does have more severe punishment like imprisonment or whipping, sebat, or the highest punishment in Malaysia is capital punishment, which is sentenced to death. So that is criminal law. But when you talk about something where you want to get damages out of it, you want to get monetary compensation out of it, it will become a civil wrong. So tort is a civil wrong. Tort is a civil wrong. So it is not a crime. You will see after this that there are certain tort that can be a crime, but tort is generally it is a civil wrong. So when you sue someone under certain type of torts, what you want is usually compensation. So it is mostly about money compensation. And why do we have tort law? Because tort law primarily concerned with imposing legal liabilities and giving remedies in respect of civil wrongs committed against recognized entities. So it means that you cannot sue everyone, but in certain situation, there are certain people that can sue and can be sued. And when you sue someone or when you are being sued by someone, it is usually about money, about monetary compensation. So for if you want to be liable under the law of contract, there need to be a contractual agreement between the parties. So both parties need to have a contract between them. Then you can claim under contract. But if there is no contract between the parties, you still can sue someone if it falls under the law of tort. So because the liability in tort is not dependent on contractual agreement. So just like what Shakila said, a party seeking redress, so seeking so usually for damages for injury that they have suffered, usually they want money out of it. But sometimes they don't want money because sometimes money is not enough to settle their problem. So money is not enough to put them in the original position before the tort was committed against them. So sometimes they don't want money. So there are we do have some less common remedies, including injunction. Injunction is one type of remedy when the court can give order to what we call it to make it compulsory for some other party to do something, or to stop from doing something. So injunction is like for situations, for example, in situations like when you have a house and your house is near company. For example, your house is near a place which is being constructed. Maybe your house is a bungalow, and then not far from your house there is an apartment which is being built. So if when they are building the apartments, something happened to your house, for example, maybe they don't do all the necessary precautions, and when they start building the apartment, it caused some cracks in your house. So dinding dekat rumah you macam dia jadi retak. There are cracks on your walls because of the construction made by the construction which is conducted near your house. So in this situation, sometimes damages is not enough. Getting money from it is not enough. So you don't want money in that situation. You want the construction to stop. You don't want them to continue constructing the building unless they have taken all the necessary precaution in order to make sure that your house is not affected by what they do to their construction place. So in that situation, you can ask for injunction. So if you ask for injunction and you fulfill all requirements, the court can make an order to tell the construction company that you have to stop building your company and do all the necessary precaution to make sure all the buildings around your construction place does not get affected. Then you can continue to build your apartment or whatever you want to build. So that is injunction. Injunction is you can ask the court to tell someone to stop doing things, or you can also ask the court to tell someone to you have to continue doing it. For example, in situations where there is a breach of contract, you want someone has breached a contract and they don't want, for example, you have a contract with a company selling some rare items, for example, selling some limited edition items, and you buy that thing from the company, but the company does not want to deliver the item to you. So in this situation, even if you sue them for damages, you don't want the money, you don't want the monetary compensation from that company, because that company is selling limited edition item. So you cannot get that item from somewhere else. You can only get that item from the company. So in that situation, you can also ask the court that you don't want compensation, but you want the court to give order to that company that you have to deliver the limited item. So that is injunction. So injunction is when you can ask people to stop doing something, or you can ask people to topic under tort, but I believe we will cover injunction under the topic of contract. But basically, that is what injunction is. So that is injunction, and another one is restitution. Restitution is putting things back into their original position. So for example, when you enter into contract and the contract is void, contract itu terbatal for due to some reasons, maybe because you signed a contract with a minor, with a person who is under 18 years old, and in that situation, the contract is void. So for a void contract, the remedies that you can get is restitution. Restitution is putting things back into its original place. So if you something from the minor, you already got money from the minor, you have to return the money to the minor, and the minor also they have to return the item that they have any benefit that they got under the any benefit that they have got from you, they have to return it back. So that is restitution. Restitution is like whatever I got from you, I have to return to you. Whatever you got from me, you have to return it to me. So that is restitution. Both I think are not going to be covered under this topic. It is going to be covered under the topic of contract. But just for your knowledge, that is what injunction and restitution is. Okay. So the functions of law of tort, there are two functions of law of tort. So the first function is it is to determine when a person has to pay compensation for harm wrongly caused. So it's not in all situations that not all situations are going to fall under tort, and not everybody is going to be not everybody is going to get compensation under torts. So there are only certain peoples and only certain situation where you can get your remedies under tort. So the function of law of torts is to determine when you have to pay. So in what situation do you have a duty towards someone else? And what situation do you have a duty? And in what situations, if you breach a duty, you have to pay for injury that you has caused to them. So that is one of the functions of law of tort. And another one is to determine what conduct may be stopped or regulated by court's order. So under the law of tort, you can also see what conduct may be regulated by court. So this one we are talking about injunction. So some conduct may be stopped. Some conduct you can ask the court to ask someone to do it. You can ask the court to order someone to do something. You can ask the court to order someone to stop doing something. So that is the what among the functions of the law of tort. So there are a number of types of torts. So we are only going to cover one of it, which is negligence. But other than negligence, we also have assault. Assault is when you threaten to injure someone. So assault, like what I said before, some of the torts is also a criminal liability. So some of these torts are also a crime. But the difference between when it is a tort and when it is a crime is the difference is if it is a tort, the level of evidence that you have to show is not very high. You only have to show evidence on the balance of probability. You only have to you only have to um, you only have to prove your case on the balance of probability, and you can get your compensation. But if it is an assault under criminal law, the standard of proof is higher. You have to prove the case beyond reasonable doubt for you to get for the accused to be punished. So that's why we do have tort, which is also a criminal offense. So usually, if the accused is found guilty under the criminal law, they will also be found liable under the tort of assault or the tort of battery or the tort of false imprisonment. So most of this assault is when you threaten to injure someone. It is also a crime under the law, which is also under the crime of assault. So for battery, battery is when you already cause some harm to another person. So battery is also a crime under the law. So under the law, it is called causing hurt, causing grievous hurt, or criminal force, using criminal force. So that is for tort of battery. It is also a crime, which is a crime of causing hurt, causing grievous hurt, or criminal force. And another one, we also have a tort of false imprisonment. False imprisonment is when you arrest someone or when you put someone in custody without justification of the law. So for example, when you take someone and you put them in a room and then you lock the room, that person cannot leave the room without your permission. So that is also what we call, if it is not justified under the law, it is what we call false imprisonment. So false imprisonment is also a crime under the law. It can be a crime of kidnap, and it also can be under the crime of false imprisonment. And then we have negligence. Negligence we are going to cover later in this topic. And then we also have trespass. Trespass is when you enter someone's property without permission. So in Malay, it's called menceroboh. So that is trespass. Trespass is also a crime under the law. It is under the crime of breaking and entering. And then we also have nuisance. Nuisance is when you do something to your own land and it causes some nuisance to the other party. For example, an easy example of nuisance is when, for example, you open a dancing club in your house. For example, you open a dancing club in your house. So as you know, dancing club is very noisy. because people are dancing throughout the night, so the music will be very the volume of the music will be very high, so it will be very noisy. And even though you are opening the dancing club is on your own land, but if it cause nuisance to your to the people who are near you, your neighbors, for example, your neighbor next door cannot sleep because of the noise made by your dancing club, you can also be liable under the tort of nuisance. So even noise, sound can also be a cause of tort. So it will be under the tort of nuisance. Interference with goods is similar like theft. Interference with goods is when you take someone's property without their permission and you put it somewhere else or you stole it. So under the law of criminal, it will be theft. But in law of tort, it's called interference with goods. And another one is defamation. Defamation is when you say something or you write something about something else, about someone else, something which is not true. So defamation is what we call in Malay fitnah. So defamation is also a crime and it is also a tort. So these are some of the types of tort that we have. But for our course and for business law, the most important one would be the law of the tort of negligence. So this is the only tort that we are going to cover for this course. Okay, so before we start with tort of negligence, do you have any question?
Miss, what about battery,
Yes.
Miss?
Battery. So what about battery? What
I don't understand about battery. Thought battery.
battery is the thought of battery is actually in criminal it is causing hurt, menyebabkan kecederaan. So battery under the law of tort, if it is assault is when you threaten to injure someone. So when you use your hand and you make it like you want to slap someone but you haven't slapped them yet, or maybe if you show your fist to someone else, that is assault. Or when you use your knife but you haven't hurt them yet, you only threaten them using the knife, that is assault. But your body, for example, you use your hand or you use your leg to kick someone, or you use your hand to slap someone, or you use the knife, that is no longer the tort of assault, but it falls under the tort of battery. So battery is when you do something to someone else without their consent. The element is when you touch someone without their consent. So it can be something as small as slapping someone, or maybe slapping them on their shoulder from the back, or maybe it can be as serious as stabbing someone. So all of that, it falls under the tort of battery. So it is similar to causing hurt under the criminal law. So that is the tort of battery. Yeah.
Okay, Miss. Thank
Yeah, you understand. Okay. So any other question about the type of tort? No question. Okay. So if there is no question, we will start with the tort that we are going to cover for this semester, which is the tort of negligence. So the negligence in Malay is what we call kecuaian. So negligence is kecuaian, and negligence is a breach of a legal duty to take care, which result in the plaintiff suffering from damage or injury. So when you commit negligence, you must have some kind of duty to take care of the other person, but you have breached your duty. You did not do your duty, and because you did not do your duty properly, it result in the plaintiff. The plaintiff is the victim suffering from some kind of damage or injury. Okay, so if you realize, I use the word damage here. So under the law, we have different definition for damage and damages. So when you hear the word damage, damage means injury or in Malay kerosakan or kecederaan. So that is damage. So damages under the law means ganti rugi or compensation. You have to differentiate that. So when for example, when you see in your assignment or maybe when you read some case, if you heard the word damage, damage means injury. Injury means kerosakan or kecederaan or any harm you done to someone's property, for example, that is damage. But when we talk about damages, damages means compensation. So in this case, it is negligence. You commit negligence when you breach your legal duty. So you have a duty to take care of someone and you breach your legal duty. You did not do your duty. And it results in the plaintiff, which is the victim, they suffer from some kind of damage, some kind of harm, some kind of injury. So that is negligence. Okay, so before we start with negligence, I have one question. If you are a visitor to a beach and when you are walking near the beach, you see someone drowning. Do you have to, if you don't save that person, is it a wrong under the law?
No.
No, madam.
No.
It's not.
Why no?
Because you don't have the duty of care to that person.
Yes. Yes, that is correct. So if you are merely a visitor, to a beach and then you see someone drowning in the sea, you don't have the duty to help that person. So even if you don't choose to save that person, it is not your fault. But if you are a lifeguard who is on duty at the beach at that time, do you have the duty to save the drowning person?
Yes.
Yes.
Yes, ma'am.
Because why do you have the duty?
You have the responsibility to take care.
You have the responsibility to take care because you are a lifeguard there, because you are working there, so you have the duty of care to save that person. But if you are merely a visitor, you don't have the duty of care. So basically
Excuse me, madam.
yes.
Can we also call that legal responsibilities?
Yes. So when you
thank you.
have so when you have the so if you are a lifeguard who is on duty on that day at the place and someone is drowning, you have the legal duty to save that person. But if you are only a visitor, you only have a moral duty. So under the law of tort, we are only concerned about legal duty. So if you have a legal duty, you are required under the law to take care of someone. So you have to take care of that person. But if you are not under any duty under the law to take care of someone, you don't have to take care of that person. If you did it, it is only out of your moral kindness. It is not a duty for you. But if you are under a legal duty to take care and you don't do your job, that you can be liable under this tort of negligence. Okay. So that is negligence. Negligence is when you breach a legal duty. So in order to succeed in the claim for negligence, there are 4 elements that you need to satisfy. So the first element is the defendant, who is if we talk about the situation that I said just now, the lifeguard owe the victim a duty of care. So the first element is we must make sure that the defendant owed the plaintiff a duty of care. So that is the first element. Once you have satisfied that the defendant does owe the plaintiff a duty of care, second, you have to satisfy that the defendant has breached his duty of care. So first, they must have the duty, and if they have the duty, they must have breached the duty. So the second element is the defendant must have breached the duty of care. And after you have satisfied that yes, the defendant have the duty of care to take care of the plaintiff and the defendant has breached his duty of care, the third and fourth element are actually talking about the same thing, which is both are talking about damage. So the third element is you must prove that your breach of duty caused the plaintiff's damage. So you must prove that you are the cause of the plaintiff's damage. It is because of you that the plaintiff has suffered some injury. So that is the third element. And then the fourth element is you also must prove that the damage was reasonably foreseeable. So the damage must be something which is what we call common. It must be something common that happened because of what you have done. So that is the four elements of negligence that you have to fulfill in order to be liable for negligence. So we will see on these elements one by one. So the first element. So the first element is the element of duty of care. So what is duty of care? When we say that the defendant owe a plaintiff a duty of care, it means that the defendant was under an obligation to be careful, to take care of the plaintiff. So, to whom do you have an obligation to take care? So, who do you have a duty of care? Nobody have a duty of care towards everybody in the world, but a defendant only owes a duty of care to the person who are in a relationship of proximity with him. So, this is actually from the case of, I think you have read this case before. Remember last week? The case of one of the questions that I asked during the tutorial. Donahue and Stevenson.
Yes, miss.
Yes. So Donahue and Stevenson is what we call a landmark case. It is the first case for negligence. So in this case, what happened is when Miss Donahue and her friend, they went to a pub. So when they go to the pub, her friend ordered a ginger ale for her. So the ginger ale was put in an opaque glass bottle. So it is put in a glass bottle which looks like this. So you cannot see what's inside the bottle because the bottle is opaque. So sorry. Okay. So when because she cannot see what's inside the bottle, so she drank. So she put some of the ginger ale into a glass and she drank it. So after that, when she wants to pour the remaining of the ginger ale, she wants to put the balance of the ginger ale inside her glass. She discovered that there is a decomposed snail inside the bottle. So when she realized that there is a decomposed snail inside the bottle, so she suffered shock. She was very shocked when she discovered that. And she got some stomach ailment from drinking the contaminated ginger ale. But it was not proven that whether it is caused by the decomposed snail. We don't know that. But because of this decomposed snail inside the bottle, she brought a case against the manufacturer of the ginger ale. So during that time, so Mr. Stevenson is the owner of the manufacturer, is the manufacturer of the ginger ale. So during this time, you cannot sue someone if you are hurt by someone's action, if you are not under a law of contract with them. So in this situation, actually, in normal situation, she cannot claim anything under the law because it is not her who buy the ginger ale. So kiranya under the current law at that time, she have no right to take any action against Mr. Stevenson. But nevertheless, she brought a case to the court against the manufacturer of the ginger ale. And what the court said? The court said that everyone have a duty to take care of their neighbor. So when we talk about neighbor in this case, it does not means that someone who live literally next to your house, but who is a neighbor in this situation is a neighbor is someone who are closely and directly affected by your acts or omission. So a person is your neighbor is if you do something, that person will be directly affected by your action. That person is in close proximity with you. So for all these persons, you must take reasonable care to avoid acts or omission which you can reasonably foresee would be likely to injure your neighbor. So if you want to do something, you have to make sure that what you do is not going to cause any trouble, and it will not cause any injury to your neighbor. So this injury must be something that you can reasonably foresee. So it must be something that you know that if you do something, this thing would happen. So that is the principle of neighbor principle. We call it neighbor principle. So it is a principle which derived from this case of Donahue versus Stevenson. So it is the main, what we call the main test to determine whether the defendant have a duty of care towards the plaintiff. So if the defendant and the plaintiff is in a relationship of proximity, so what is the relationship of proximity is when if someone is closely and can be affected by your action, then you have a duty of care towards that person. So one question, if you are a worker at a bank, to whom do you owe a duty of care? As an officer at the bank, to whom do you owe a duty of care? Who are the people who are closely and directly affected by your actions? For a person who works in a bank?
The customer,
Yes, the customer. Other people?
the staffs,
The staff? Anyone else?
Employer.
Sorry, the employer. So basically, for a worker in a bank, the person who is their neighbor, the person to whom they owe a duty of care, it is usually the customer, the most important one, their colleague, their fellow employees, and also the employer. So, so I think you already understand the definition of relation of proximity. So, proximity is when someone who is closely, and that person will be directly affected by your action. So this is the neighbor principle. So if that person is closely and directly affected by your action, that person is your neighbor, and when that person is your neighbor, you owe a duty of care towards them. Okay, so this is the landmark case. Okay, so the neighbor principle is an objective test. So when you want to determine whether you have a duty of care or not towards someone, the court will ask this question. The question is, would a reasonable man who is in the same circumstances of as the defendant foresee that his conduct will adversely affect the plaintiff? So when we talk about reasonable man, we are talking about someone who is in the similar situation with the defendant. For example, if we use the example of officer, bank officer that I said just now, a reasonable man, if you want to see whether a banker's action, if you want to see whether a bank to whom a bankers owe a duty of care, they will look at another banker. So another banker is the reasonable man. So when we talk about reasonable man, we have to put them one side to side with the person who is under the same circumstances. For example, if you want to if the defendant is a banker, you have to use the a reasonable man who is another banker. So, or if the defendant is a doctor, you have to use another reasonable man who is also another doctor. So that is a reasonable man. So a reasonable man, would a reasonable man who is in the same circumstances as the defendant foresee that his conduct will adversely affect the plaintiff? So if another doctor can foresee that what he's done will adversely affect that plaintiff, so the plaintiff is a neighbor of the defendant. So if another doctor cannot foresee that his conduct will adversely affect the plaintiff, so the plaintiff is not a neighbor of the defendant. So in the situation like for a banker, the customer, employee, and another employer is a very clear example of the person who is a neighbor to a banker. But there are in certain circumstances where the who is the neighbor is not very clear. So like in this case, oh no, I think we'll discuss it in the breach of duty. So when you want to prove whether a defendant owe a plaintiff a duty of care, three factors need to be considered. So first, there must be a relationship of proximity between the plaintiff and the defendant. So the plaintiff must be closely and directly affected by whatever a defendants had done. And the second one, the damage must be reasonably foreseeable. So you not only have to prove that there is a relationship of proximity between the plaintiff and defendant. You not only have to prove that the plaintiff and the defendant is a neighbor, but you also have to prove that whatever suffered by the plaintiff is something that the defendant can foresee, something that defendant boleh agak akan berlaku if he did something wrong. So the damage must be reasonably foreseeable. And the third factors is must also be fair, just and reasonable to impose a duty of care on the defendant. So this is usually on the part of public policy. So for the first one, there must be sufficient closeness. For the term of reasonable man, we will look again on the definition of reasonable man under the second element, which is breach of duty. So to prove that someone is a neighbor of the defendant, there must be sufficient closeness. They don't have to be physically near each other, but whatever the one person's did must affected the other person directly and closely. Then they will have relationship of proximity. So for example, employee versus client or between office mates. And then one case. In this case, the developer is building a 20-story condominium plaintiff's bungalow. So the plaintiff is the owner of the bungalow, and the developer is building two 20-story condominium adjacent to the bungalow. So the building the condominium is literally next to the bungalow. But the developer did not take any precautionary measure prior to the construction to ensure that the neighboring bungalow was not affected. So they have to do something to strengthen the land, but they did not do it. So they did not take any precautionary measure. So when they start to build the condominium, it caused damage to the owner's bungalow. That's like the example that I give just now. If I'm not mistaken, what happened to the bungalow is it caused crash of the bungalow. So in this case, Yu Sim Chuan take action against the developer, and the court held that the developer is liable. So because in this situation, because the bungalow is in physical proximity with the construction site, the bungalow is literally adjacent to the construction site. So whatever the developer did on the site, it could affect the bungalow. So in this case, the court have instructed the developer to take all the precautionary action before they can continue to build the bungalow. So in this situation, it is they are literally neighbors, but there are also other situations where literally neighbors, but whatever you do, because it had affected the other person, that person also have can claim against you. So this is the for the first one. For this case, for example, in this case, not only you have to prove that that person is closely and directly affected by your action, but you also have to prove that your act can cause injury to the plaintiff. So you must reasonably foresee that what you do will cause injury to the plaintiff. For example, in this case of Borhley and Young, in this case, Mr. Young, a motorcyclist, crashed with a car. So a motorcycle get into an accident with a car, and during the accident, the motorcyclist died. So the motorcyclist died during the accident, and Miss Borhill is nearby the area. She is not there when the collision happened, but she is nearby the area. She is not far from there, and she heard a loud crash sound. So you know that when a collision happened, they will have this kind of screeching sound, and then they will have a crash sound. So she is nearby the area, and she heard a loud crash sound. So when eventually get to the accident site, she saw traces of blood. She saw blood at the accident site, but she did not see any mangled body or any dead body, because when she eventually came to the accident site, the body had been removed. So all she saw was traces of blood. dia cuma nampak darah je dekat kawasan accident site tu. So when she heard a loud crash, she saw she saw traces of blood, and the traces of blood, at that time she was 8 months pregnant, and later she gave birth to a stillborn child, so her child died, and she claimed she filed a claim against the, I'm not sure she filed a claim against the car driver or the motorcyclist, but she does file a claim against one of the people who are involved in the accidents. She claimed that because she saw blood at the accident site, she suffered from nervous shock. So she said that she was so shocked, she suffered nervous shock. She is so shocked because of the blood that she saw, and because of the sound that she heard, that it caused her to give birth to a stillborn child. So she wants to claim for negligence. She wants to say that um, the people who are involved in the accidents are negligent, and it caused her to and it affected her and caused her injury. So her injury is in the form of she gave birth to a stillborn child. So she want to claim for negligence. But in this case, the court held that Mr. Young did not owe Miss Borges because at the time when the accident happened, she was not in immediate danger, because as I said before, she was not at the place of the accident. She was not at the accident site. She does not see the car and the motorcycle crash into each other. She only down, and it was not foreseeable that she could have suffered nervous shock as a result of seeing the accident scene, because all she saw was blood. So in this situation, the court held that the defendant does not owe the plaintiff a duty of care, because it is not foreseeable that someone who is not at the accident site would have suffered nervous shock because of the accident scene. So in this situation, the plaintiff is not closely and directly affected by the defendant's action, but the damage that she has suffered is not foreseeable. So in this case, she cannot claim because there is no duty of care against her, because they did not owe any duty of care against her. So that is another case. For the last one, like I said, for duty of care for policy, they decide that it's not fair to impose the duty of care on the defendant. Usually, when a defendant is a local authority or or it is the government, care will have negative social, economic, and political repercussion. So sometimes the court will say that even though in normal situation, they might owe you a duty of care, but because it is not fair to put a duty of care on the person does not owe any duty of care towards you. So that is the first element, the element of duty of care. Any question about the element of duty of care?
Madam,
Yes.
thinking about the previous example that you showed just now about the motorcycle crash and the blood.
Mm-hmm.
The court also has a decision to call upon medical experts to examine Mrs. Bond's situation to actually show that it was actually a cause of trauma and shock also, right?
I'm not sure in that case whether I'm not sure in that case whether they take the opinion of an expert. But in that case, actually they said that they don't have any duty of care is because she is not at the accident scene. The main issue is because she is not at the accident scene. And the injury that she suffered is more to nervous shock. So she said that it is psychiatric illness. She said something. She is mentally affected, but because I think in that case, because she is not at the accident scene, so it is not fair to put a duty of care on the defendant because the plaintiff is not there. The plaintiff is not there, and the plaintiff is not in immediate danger. It's not like she was literally at the accident site. I believe that maybe if she is near the accident site, the court may say that that defendant have a duty of care towards her. But at the time, because she is not in any immediate danger, so the court said that she does not. So the court said that the defendant does not have any duty of care towards her. But I'm not sure in that case whether they have expert opinion or not. I have to check back on the case.
Okay, thank you, madam.
Uh, no other question. Okay. So if there is no other question, we will continue with the second element of negligence. So the first element is you have to prove that the other person, the victim of the plaintiff in that case is your neighbor. That the plaintiff must be someone who is closely and directly affected by your action. So once the plaintiff has proved that the defendant owe a duty of care towards her, the second element that have to be proved is the plaintiff must also prove that not only the defendant owe a duty of care towards her, but also that the defendant has breached his duty. So what is the test? So for the duty of care, the test is neighbor principle. So for breach of duty, the test to prove whether someone has breached their duty is to determine, would a reasonable man have acted as the defendant has done if the reasonable man was faced with the same circumstances as the defendant. So for breach of duty, the test relevant is what we call a reasonable man test. So when you want to know whether someone has breached their duty or not, you have to take another person who is in the same situation, same circumstances as the defendant. So that another person is who we call a. So who is a reasonable man? A reasonable man is someone who is neither careless nor overly careful. So a reasonable man is someone who is not a very, for example, if you want to compare between a doctor and another doctor, they cannot use the example of a very bad doctor. You have to use but you also cannot use the example of another very good doctor. So a reasonable doctor, if you want to compare between a defendant doctor with another doctor, you have to use a reasonable doctor who is neither careless nor overly careful. So just another doctor who is a common doctor, not a very good doctor and not a very bad doctor. So that is a reasonable doctor. So the defendant will be judged against a person who possess the same skill as him. However, there are circumstances, for example, for a learner driver would not be compared against another learner driver. A learner driver, for example, for someone who is still taking their driving license at the driving school, if they get into an accident with another person, they will not be judged against another learner driver, but they will be judged against a competent driver. But in other situation, for example, you want to compare between a junior doctor, for example, a junior doctor will be compared with another junior doctor. He will not be compared with a specialist. Defendant is a jeweler. The defendant will be compared with another jeweler, not another person. So there is the defendant will be judged against a person who possess the same skill as him. So for example, in this case of Philip against Whiteley, In this case, the defendant was a jeweler. The defendant worked as a jeweler and offered this service of piercing people's ear. So the plaintiff went to the defendant to have his ear pierced, which is properly sanitized. And then the defendant also dipped the instrument in disinfectant, the instrument that he used to pierce the plaintiff's ear. He already dipped the instruments in disinfectant. He already passed the instrument through a flame, and he already put the instrument under running water. So basically, the defendant has done whatever is needed to be done by by any jeweler if they want to pierce someone's ear. But unfortunately, after the plaintiff got his ear pierced, he contracted disease after the procedure. So the plaintiff contracted some kind of disease related to the piercing of the ear, and he claimed against the defendant. So in this case, the court held that the standard of care required from the defendant was of a skilled jeweler, not a medical practitioner. So he will only be compared with another jeweler. He will not be compared against a skilled surgeon or a doctor. So in this situation, because the defendant had met the standard required, what he did, performing room, dip instrument in disinfectant, pass them through a flame, place them under running water. That is the standard SOP. That is a standard operating procedure on how to pierce someone's ear, and he had done it properly. So because he had done everything that he has to do, the defendant had met the standard required, and he has not breached his duty of care towards the plaintiff. So in the case of negligence, it is like this. You, even though someone is injured because of your action, it doesn't mean that in all situations when someone is injured because of your action, you will be liable. For breach of duty, you only have to prove that you have done everything that you need to do properly. So what you do is you have done everything properly, and what you had done is just the same, similar with another person. If you go to another person, the other person will do just the same thing as what you did. If you had done everything you have to do and you have done everything properly, that if even if someone is injured after that, that person cannot take any action against you, because the court will say that you have done everything you have to do, so you have not breached your duty of care, even though the victim has suffered damage. So that is in a situation of negligence. So like in this case, as long as you do everything you have to do properly, the plaintiff cannot take action against you, even though he has suffered some kind of damage, he has suffered some kind of injury, as long as you have achieved the required standard of care. Okay. So in different situation, there are different standard of care required. There are 4 factors that we have to determine to see how high is the standard of care in a certain situation. So the 4 factors is the first one is the magnitude of risk, whether the risk is high or low. If the risk is high, care is high or low? For a case, if the for a situation where the risk of injury is high, to do, or if the risk is high, what do you guys think? If the risk of injury is high, do you have to do more to achieve your standard of care, or do you have to do less to achieve your standard of care? And
Madam?
yes.
Excuse me, madam?
Yes.
Can this also be considered to expert in profession wise to how much cash should be given towards the situation?
Yes, that is also true. For someone who is more skilled, they have to they have a highest, but also if the risk is high, they also have to do more. So if the risk of injury is high, they have to do more to achieve the standard of care in order not to be liable for negligence. But if the risk is low, they don't have to achieve a too high, I mean the standard of care is not too high. It depends on the risk. Yes, it also depends on the skill, but it also depends on the risk. So if the risk is high, you have to do more. If the risk is low, you have to do less. So that is one of the factors. We will see on that later. And then the second one is practicability of precaution. How practical is the precaution? If the precaution is easy to do and is practical, you have to do it. But if it is not practical or too hard to do, you don't have to do it. And then the third one is the general and approved practice. So this one is easy as long as you follow the proper practice. So it is what is done by everyone else. So you can see that you have achieved the standard of care. And another one is in certain situation, they will have a different standard of care depending on the situation. So we'll see each of these one by one. So the first one, the magnitude of risk. So the degree of care required of the defendant must be weighted against the magnitude of risk or degree of risk created by the defendant's action. So like what I said before, and like what Ain already said, if the probability of injury occurring is high, higher standard of care is required. So it is something, for example, if the accident has happened very often, or if the injury or if the incident had happened so many times, so it means that the probability of harm is high, the probability of injury is high. So in that situation, higher standard of care is required. For example, in this case of Susan Chia lawan Maybank Finance, in this case, a break-in occurred in the strong room of the defendant's premise. So as you know, in all banks, they do have their bilik kebal. And then a break-in occurred in the strong room of the defendant's premise. And in the strong room, they put all the safe deposits. So that room was break-in. The burglars had tunneled down the ground. So the burglars in this case is very creative. They had used a tunnel underground to get into the strong room. So in this case, is one of the customer whose items in the safe deposit box has disappeared. So Susan, so in this case, the court held that the defendant is liable for the plaintiff their valuables because as you know, and as the defendant should have known, a strong room. So if someone got to break into that strong room, the problem maksudnya people will a high amount of loss if someone got break into that strong room. So in this case, the defendant said, the court said the defendant is liable for the loss of the valuables of the plaintiff because the defendant, okay, why? Because at that time they are already a more advanced security system to protect the bank from being broken in, but they have not installed the advanced security system. And what more, the advanced security system was easily available and it had been in the market for 10 years before the incident occurred. So the advanced security system is not even a new technology. It is a very mature technology which has been in the market for 10 years. But because the bank, for some reason, maybe because they want to save money, or maybe because they don't think it is important to upgrade their security system. So by not installing the advanced security system, the court said that the defendant has acted below the reasonable standard of care. So in this case, the defendant was found liable. was found liable for negligence, which caused the plaintiff to lose their valuables. So it's like this. So and then for another case, if the action may cause serious injury to the plaintiff, higher standard of care is required. For example, if you do a very hazardous job, very dangerous jobs. So for people who are working in very dangerous jobs, their employer have a high of care to make sure that their employee is safe. Their employee is not does not suffer any injury due to any mistake. So if the by the plaintiff is high, defendant also is required to have a higher standard of care. For example, in this case of Paris against Stephanie Borough Council. In this case, Paris is a worker who only have one eye. So this Paris is already a disabled person. He only have one eye. So when he worked for Stephanie Borough Council, the council does not provide him with any goggles, with any safety goggles. So because he do his work without using the safety goggles, a piece of metal hit the plaintiff's eye when he was working, and it caused him to become blind. So this person, Paris, before this he was a man with one eye, and because of the incident where the metal hit his eye, he became a totally blind person. So the court held that an employer had a duty to take reasonable care to ensure the safety of the working environment of his employees. And in this case, the court said that the goggles should have been provided, especially for the plaintiff, as the consequences of any accident to him would result in his losing his eyesight. So this case is quite controversial because some people say that not only people with only one eye have to be protected, even people with two eyes have to be protected. But basically, it means that if the work is dangerous, the highest standard of care is required. Or if the case has happened so many times before, the standard of care is higher. The standard of care required is higher. So it depends. So to see whether a standard of care must be higher or lower, one of the things that you have to consider is if it may cause serious injury, you must have higher standard of care. So you have to do more to make sure that your employee or the plaintiff does not suffer any injury. Another one, if the case happens so often, for example, if there is a road which has been an accident site for so many years. For example, when if there is a road which so many people have crashed at that place, so many accidents had occurred at that place. So if there is such place where accidents occurred so many times, for example, if it happens on a highway, for example, there is one stretch of highway where accident happens regularly. Every month there will be at least one or two accidents. In that situation, plus, for example, if the highway is plus highway, plus have a duty of care to to do something to make sure that the place will not cause injury to anyone using that place. Because it has happened so many times. Similarly, if accident, for example, if the work is something very dangerous, and if something happened, the risk of injury is very high, and the injury suffered will be very serious. And in that situation, also higher standard of care is required. So that is for factor one, which is the magnitude of risk. So you have to consider the magnitude or the degree of risk to determine whether the standard of care required is higher or lower. So that is the first factor. Any question about the first factor?
Madam,
Yes.
is what about government
Government, sorry.
stated guidelines on safety procedures? Is that like any, sorry, madam, how about any breach of government safety procedures? Because clearly they weren't following procedures when taking care of the employees. So can that be considered like a breach of a violation of a violation of a safety code or anything inside the government?
Really, yes. I think you all are also aware that we do have this one act done something which is if the government had done something which is against their standard operating procedure, actually it is something that you can take action against. But you do know that taking action against the government, they have their own limitations here and there. Like for you, when you see for the duty of care, the court will also consider whether it is reasonable, fair, or just to put a duty of care on the employer. So you have to consider all those things. But actually, we do have the Act, OSH Act, and whatever is stated in the Act, actually it have to be followed by all the employers. It doesn't matter whether it is a government employers or private employers, especially when it concerns occupational safety and health. For example, the safety of your office and whatnot. Does that answer your question?
Yes, yeah, yes, madam. Thank you very much.
Any other question? No other question. Okay. So if you don't have any question, we continue with the second the second factor that you have to be that have to be considered in order to determine the level of standard of care required of the defendant. The second one is practicability of precaution. If the risk is too small compared to the higher cost of taking precaution, a defendant is not expected to guard against the small risk. So for example, if the risk is too small, I mean the risk is very remote, but the cost of taking precaution is very high. I mean that the thing doesn't happen often, and the risk of that thing happening is very small. But if you want, you can still take extra precaution. But if you want to take extra precaution, you have to use more money. It have a very high cost. So in that situation, a defendant is not expected to guard against a small risk. For example, in this case of Latima against AEC, in this case, factory was flooded due to heavy rain. So heavy rain had occurred around the area, and the factory was flooded. And because there are lots of oil and water, mixture of oil and water around the factory, so the factory's floor is very what we call very slippery after the heavy rain because of the mixture of water and oil, so it becomes very slippery. So the owner of the factory, in order to reduce the risk of injury occurring, they had tried to cover all the slippery part of the factory with sawdust. So they used this habuk kayu sawdust to cover all the slippery part of the factory to make that place to put more friction on that place so that it doesn't become too slippery. However, not all of the slippery area was fully covered. Unfortunately, not all of the slippery area was fully covered, and one of the workers there, the plaintiff, had slipped on the slippery area, and that a worker fell. So he slipped and fell. So he claimed for negligence against the defendant, against his employer, and he contend that um, putting sawdust on all the slippery part of the factory is not enough. You are supposed to shut down the factory completely to make sure that the place is safe to work at. So he said that the defendant should have shut the factory down because in this situation the owner, the employer, the owner of the factory does not have any choice. The only choice they have are two. One, use the sawdust to cover all the slippery area to put more friction so that people will have less risk of injury. Or the other option is shut down the factory completely because of the flood. So this worker said that defendant should have shut the factory down. So in this situation, the court held that the risk of injury is too small to warrant the shutting down of the factory. So the risk of injury is not sufficient to warrant the shutting down of the factory because they have tried to increase the safety of that place by putting the sawdust. So the court said the risk of injury is insufficient, and because the risk of injury is low, and it will be unfair to require the defendant to spend a lot of expense to reduce the risk. So the court stated that shutting down the factory will cost the employer too much money. So because the risk of injury is low and the cost of taking precaution, the best precaution is closing down the factory, is the cost is very high. That's why whatever the defendant has done, it is maksudnya he said that the employer has not breached his duty. So he has done his best to make sure that the place is safe to work at. So he said because of that, the defendant is not liable for negligence. So in this situation, we can see that if the cost to take precaution, maybe you said that they should have done more, but the court will see that if the risk of injury is too small, but whatever the employer should have done is too high cost, it is very costly, it is too costly, the court will say that because the risk is low but the cost of taking precaution is too high, it will be unfair to ask the defendant to spend a lot of expense just to make sure that it is 100% safe. So in this situation, the court said that no, you already reached you already achieved your standard of care. You are not liable. You have not breached your duty. So that is the second factor. And then the third factor is a general and approved practice. So if whatever the defendant did is something which is consistent with the standard practice in his industry, it follows the proper SOP. Any other company have done the same. It is a general practice in the industry. He can be said to have acted reasonably. He can be said to have achieved his standard of care. However, if the standard practice is something very dangerous, so if the standard practice is something dangerous, a court may still find the defendant's conduct to be negligent. For example, in this case of general contractor versus Christmas, in this case, the general practice is when a window cleaner clean a window. This is a very old case. So in this case, the standard practice of the industry is if a window cleaner wants to clean a window, they will usually stand on the latch of a window. Latch of the window is underneath the window. Usually they will have some small latch. So usually they will stand on the latch and clean the windows. And during this time, they are not required to wear any safety. They are not required to wear any proper safety equipment. So in this case, a window cleaner stood on the latch of a window. The latch is around 6 and quarter inch. 6 and quarter inch is around the length from between your two fingers, around 6 to quarter inches in width. So while cleaning a window 27 feet above the floor, above the ground, I think it is around 27 feet. I think it is on the 4th floor, I think. I think it is on the second or the third floor. So this window cleaner stood on the ledge of a window, 6 quarter inches in width. So he was cleaning a window 27 feet above the ground. I think it's on the second or the third floor. So when he was cleaning the window, he did not wear any safety equipment. He merely stood on the ledge, so he fell. He fell down and he injured himself. So at that time, it was a common practice. At that time, it was a common practice for these window cleaners to stand on the window ledge, and it is also a common practice not to wear any safety equipment. So at that time, if you want to compare this window cleaner with another window cleaner, what he is doing is just the same, like what other window cleaners are doing. But in this case, the court held that even though it was a common practice for window cleaners to stand on the window ledge while performing their jobs, the practice was dangerous. So in this situation, because it is something very dangerous, the defendant was still liable for not providing a safer system of work. So you can see from this case that even though something is common, even though it is something which is a standard practice, but if the standard practice is dangerous, if the standard practice is something which is clearly wrong, you still will be liable for not achieving the required standard of care. So that is the third factor. And then the last factor is the social importance of the act of the defendant. So in certain situations, if what the defendant is doing is something very important, sometimes he is allowed to incur some risk of injury to complete his work or job. So this one are usually applicable in like rescue situation or maybe emergency situation. For example, in this case of Watt versus Hertfordshire County Council, in this case, a woman was trapped under a lorry. So they call the fireman for help because this woman is trapped under a lorry. So they need some kind of jack to um, use to lift the lorry in order to save the woman. So the jack it is like your normal jack. It is a hydraulic jack, but it is a very huge one. It is a very huge hydraulic jack because it is needed to lift a lorry. So wait, I'll show the jack to you. So this is the jack. The hydraulic jack is a very large jack because it is required to lift a lorry, not a small car. So the hydraulic jack is supposed to be. The hydraulic jack is actually. The hydraulic jack is. The hydraulic jack is supposed to be brought using another special fire engine, but at that time the special fire engine is not available, so they use the jack using so they brought the jack using a normal fire engine which does not have safety features to help the jack. So during the way, the jack fell, so it hurts one of the firemen. So the fireman, which is the plaintiff, he take action against his employer. So in this case, the court held that the defendant was not liable because this is an emergency situation. It is very important that they take immediate action because they have to save the woman. So at that time, some risk of the risk of injury is not very high compared to the importance of saving another's life. So like I said, if it is in a situation of maybe in a rescue situation or maybe in emergency situation, if the workers or some other people got injured due to the rescue mission or due to the emergency situation, the court might held the defendant not liable because it is emergency. So it is more important to save another person's life. So some risk of injury is still okay. So that is for breach of duty. Any question about breach of duty?
No, madam. Thank you.
No question. So if there is no question, I'll give you a 10 minutes break until what time is it now? Until 10:25, and then we will continue with our remaining slides. Okay, so I give you 10 minutes break to maybe wash your face or take some more water downstairs. Okay, so I see you
Thank
in
you,
10
Miss.
minutes time. Thank you. Okay, hello all. We'll continue with our class. So we'll continue with the third and fourth elements, which are damages. So first, you have to prove that you owe a duty of care towards the plaintiff. So if you have proven that you owe a duty of care, second one is the plaintiff also have to prove that the defendant has breached the duty. So we already see before this what are the standard of care required in different situations. So if the plaintiff has proven that the defendant owe a duty of care towards her and the defendant has breached his duty. So the third and the fourth element that need to be proved is damages. So the plaintiff has to prove that one, the causation of damages. The causation of damages is, the causation of damage, which is the plaintiff must prove that it is the defendant who caused the injury to the plaintiff. So it is the defendant's action that has caused the plaintiff to be injured, to cause the plaintiff to be harmed. So that is the first element of damage that has to be proven. And the second element is remoteness of damage. So not only the plaintiff has to prove that the defendant caused the damage, the plaintiff also have to prove that the damage suffered by the plaintiff is a type of damage which is reasonably foreseeable, something that the defendant can foresee will happen due to his action. So that is the two elements of damage that have to be proven by a plaintiff in order to succeed in a claim for negligence. So for the first element of damage, which is causation of damage. So once it is proven that the defendant has breached his duty, the plaintiff must prove a connection or causal link between the defendant's breach of duty and his injury. So he have to prove, in simple words, he have to prove that the defendant's conduct caused the plaintiff's damage. How to prove that is by using the but-for test. So we can see for the duty of care, the test is neighbor principle. For breach of duty, the test is a reasonable man test. And for causation of damage, the test is but-for test. So what is but-for test? But-for test is based on this case of Barnett against Chelsea and Kensington Hospital. In this case, there are three security guards. The guards who were on duty, they shared a tea. So the tea they drank was a poison tea. The tea contained arsenic, which is a kind of poison. So 20 minutes later, they began vomiting. So they began vomiting, muntah, and they went to the hospital. So when they went to the hospital, the doctor on duty thought that they only suffered from diarrhea or food poisoning. So the doctor on duty told them to go home because he presumed that it is not an emergency. So these three men returned home. So 9 hours after drinking the poison tea, one of the security guards died. So the widow of the security guard, so Barnett, sued the hospital. So the wife said that the hospital is negligent by failing to treat her husband. So she said that because the hospital failed to treat her husband, that's why her husband died. So in this case, the court held that the hospital was not liable. So in this situation, yes, the hospital did owe the man a duty of care because the men are patients. So the hospital did owe the man a duty of care to examine them. So the hospital does have a duty of care towards these patients. So because they have not examined these patients properly, they has breached their duty. So they failed to do so. So they has breached their duty of care by failing to examine the patients. However, because it cannot be proved that the victim's death is the result of what the hospital did, so the hospital is not liable. So in this situation, yes, the hospital owe a duty of care towards his patients to treat to examine all the patients properly. And yes, the hospital did breach their duty by failing to examine the patients because the hospital, instead of checking whether there was something wrong with these people, the hospital just presumed that these patients are suffering from food poisoning and asked them to go home. However, because the victim's death is not caused by the failure of the hospital to treat them, the hospital is not liable. So in this case, the court said that the victim has been poisoned with arsenic, with a type of very potent poison, and examine the patients. Even if the doctor has treat the patient will still die, because at that time there is no cure for arsenic. So once you got poisoned by arsenic, it is like a death sentence to you. There is no cure for that. So in this case, the court said that because even if he is treated properly, he will still die. So because of that, the damage suffered by the by the plaintiff is not caused by the breach of the defendant's action. So there is no link between the breach of duty and the death of the victim. So because there is no link between the breach of duty and the death of the victim, the court held that the hospital was ultimately not liable for the death of the man. So it's like from this case, we can see that if the plaintiff would still suffer damage, even though the defendant has done everything that he can do, the defendant will not be held liable for negligence. So there must be a link. So whatever happened to the plaintiff must be directly caused by the defendant's breach. So that is for causation of damage. So what if there are multiple causes that contributed to the plaintiff's injury? So what if the plaintiff injury is caused by not one cause, but by multiple causes? So if the plaintiff's injury is caused by multiple causes, plaintiff's injury is a result of multiple causes. This breach was an important cause of damage. So he only have to prove that most important cause. That is one of the main reason why he suffered the injury, why he died, why he is injured. Causes, the defendant's action was one of the main reason. Like in this case, Wilshire, in this case, a junior doctor has negligently administered an excessive amount of oxygen for premature baby. As we know, they cannot be given excessive oxygen, and they cannot be given too little oxygen. So they have oxygen on the baby to be. So it is a well-known fact that if you administer excessive amount of oxygen on a premature baby, it can cause the baby to be blind. But at that time, there are also 5 other possible causes. So this baby's condition is not very good. So not only she was not in a very good condition, but she was also, on top of that, she was given excessive amount of oxygen. So because of that, there are like 6 reasons why the baby will become blind. So in this case, the court held that as it was not proven that the blindness was caused by the prevent access of oxygen, the defendant is held not liable. So in this case, because the plaintiff cannot prove that I'm blind. So in this situation, because they cannot prove it, they cannot claim. But there is this other situation. This person was stabbed. So this plaintiff was stabbed by the defendant. So the defendant stabbed him, and then he was brought to the hospital. On the way to the hospital, he was dropped twice by the medical by the medical team. For example, so he first he was stabbed by the defendant, ditikam oleh defendant, and then way to the hospital, he was dropped. His stretcher, something happened, it dropped twice. So due to the stabbing, but also due to the dropping of the stretcher twice. So in this case, who do you think caused the injury of the plaintiff in the situation of this stab victim? Can he sue the hospital, or can he sue the defendant only?
Defendant.
Defendant. Why?
The cost.
Because the cost.
Because the defendant that stabbed him.
Okay. So you said that because the defendant is the one who stabbed him, still the main cause of the injury is the defendant, right?
Yes.
Anyone else? Anyone else? Anyone else have any other idea?
Maybe the medical team, madam,
The medical team. Why?
because they perform it to become more severe than the defendant.
Okay. Anyone else? No one else.
Maybe
Okay,
both,
so
madam.
maybe both. Yeah, I like the answer both. We just suit everyone we can, kan? Okay. That is actually another case. I can't remember the name of the case, but in that case, the court held that the one who is responsible, who is responsible for the injury of the plaintiff, defendant. Okay, because the court by the plaintiff, kalau plaintiff tak tikam defendant, the defendant would not be needed to be brought to the hospital, which caused his to be more severely injured. So the court said that in that situation, the main person who caused the injury of the plaintiff is the defendant, because in the first place he's the one who stabbed the plaintiff. So the claim would be higher. The claim would be best. So I mean the plaintiff would have to claim against the defendant for damages, because he is the one who caused the stabbing, because he is the one who stabbed. The hospital only what we call increases the severity of pain lies with the defendant. Okay, so that is for causation of damage. So another one is remoteness of damage. So you not only have to prove that the defendant caused the damage to the plaintiff, but you also have to prove that the defendant can reasonably foresee that his doubt will result in some damage to the plaintiff. So it means that the damage caused by the defendant to the plaintiff must be a reasonably foreseeable damage. So it must be a damage which is common in that situation. So if the damage is remote, if the damage is so unnatural, if the damage is so is something which is not foreseen, defendant will not be liable. So in this case, the test is whether a reasonable man could have foreseen the damage as a likely consequence of the defendant's action. So you have to see if injury suffered by the defendant is a normal type of injury. So for example, in this case, the case of Bradford against Robinson Rentals Limited, in this case, the defendant had asked the plaintiff to run an errand. So it was during winter time, and the defendant had asked the plaintiff to use his van to run some kind of errand. So the van used by the plaintiff did not have a heater. So he was freezing cold inside the van, and the plaintiff suffered frostbite in consequence because there is no heater in the van. So in this case, the court held that frostbite is a type of injury which is reasonably foreseeable. It is not a type of remote injury, because everyone knows that if you are exposed to cold weather for an extended period of time and there is no heater, you will suffer from frostbite. So because it is not a remote injury, it is something which is reasonably foreseeable, the defendant was liable. Um, However, we also have this one concept which we call eggshell skull rule. In this eggshell skull rule, it said that a tortfeasor must take his victim as he finds him. It means that as the defendant, once it is proof that you had caused some. So if the victim is somehow is someone who is weaker than most people, or maybe your victim is someone who is very old, very sick, you cannot argue that you cannot argue that yes, I am wrong, I have committed some kind of negligence, but the plaintiff injury would be less if you did not have if the plaintiff did not have unusually thin skull, or if the plaintiff does not have weak heart, or if the plaintiff is not someone old, someone sick. So you can argue that a tortfeasor must take his victim as he finds him. So like in this case of Smith against Leach Brain and Co Limited, in this case, the defendant does commit some kind of negligence. So the negligence caused the plaintiff's husband to burn on the lip by a piece of molten metal. So the plaintiff's husband to, but unfortunately for this defendant, unfortunately for the defendant, the plaintiff's husband was someone who has a tendency to contract cancer. So, burn on the lip, tendency to cause the burn cancerous growth, and in the end, it caused the plaintiff's husband to die. So in this case, the court said liable for the plaintiff's husband death because even though an ordinary healthy person would not have developed cancer in the same circumstances, the defendant has to take the victim as he is. So in this situation, the defendant is unlucky to have a victim who is prone to cancer. So, but whatever it is, because he has to take his victim as he finds it, as long as he is found liable for causing the injury, he still is liable for the death of the plaintiff's husband because of this eggshell skull rule. Okay, so that is the fourth, which is the continuation of this topic. We will learn about vicarious liability. In what situation does an employer have to pay for the negligence caused by his worker? Look on the defenses for negligence. So defenses means that even though you has committed negligence, you have a duty of care, you has caused some kind of damage to your plaintiff, but there are certain situations where you either don't have to pay, you are not liable to pay for negligence, or you still have to pay, but the amount that you have to pay will be reduced. So that is all under topic 3. But before we continue to topic 3, do you have any question about topic 2? You have any question on the elements of negligence? Before we continue with the next topic.
Excuse me, madam. Madam.
Yes.
Sorry. I was actually kind of thinking about the eggshell rule, the skull eggshell rule, the previous slide. What are the factors that determine such a ruling to be told on the court of law?
What you mean? Can you repeat your question? I don't understand.
What determines the court to rule in individual under the rule that is followed, the skull eggshell rule? What determines it actually, madam?
Because I believe, that is what I believe, I have to recheck, but what I believe is that the court does not want to differentiate between a healthy victim and a not so healthy victim. Because if the court does not use this eggshell skull rule, people will start to argue that yeah, I know that I commit some kind of negligence, but if that person is not so weak, even if I slap him, he would not suffer a very serious damage, a very serious injury. So the court, I believe, I have to recheck this, but I believe the court feels that the defendant would not argue on the fact that the victim is too weak. That's why he suffered damage. The court is more concerned about the defendant has committed some wrong. The defendant has committed some wrong, and it has been proven he has some kind of duty and he has breached his duty and it caused damage. It doesn't matter if the victim is a stronger person or a weaker person. So you still have to pay because you have committed wrong against him. I believe that that is the reasoning of the court, but I have to double check on that. Okay, Saresh.
Understood.
Okay, and I think Atira Anis also want to ask question just now. Ask question?
No, madam. It's nothing.
Oh, I thought you want to ask question. Anyone else?
Sorry, madam.
Yeah,
I have,
yeah.
I have one question actually. Okay, for the negligence, right?
Mm-hmm.
So let's say, like what Madam has mentioned, okay, let's say the Leburaya Plus, okay, we take, there's some damage on the road, okay, that cause accident
Mm-hmm.
to the driver, okay, then how should the case to be brought? Is it the federal court or what?
Federal court meaning if for example if the case happen between maybe a road user and at the accident happens because the road user uh, run into some kind of hole on the road and then he suffered some kind of damage. So in that situation, the road user, the one who suffered from the accident, will take action against Plus Highway for tort of negligence because Plus Highway is the people who are supposed to make highway. Usually the case will be brought by the victim against Plus Highway. We will see after this on the of vicarious liability why they take action against Plus, not on the worker who did not properly maintain the road. But the case will usually be brought against Plus Highway, and depending on the amount of claim, if the claim is less than 1 million, the case will be heard by the Sessions Court. If the claim is less than 100,000, oh no, road accident will be the case will be heard by not the federal court. It will be because it is because the situation of highway, because it is a road accident, it will be heard by the Sessions Court. On the other hand, if the accident happen not on the road, so it is not an accident, some kind of injury, the case will be heard in different courts depend on the amount of claims. Is less than 1 million, the case will be heard in the Sessions Court. And if it is if it is more than 1 million, the case will be heard at the High Court. Does that answer your question, Hadi?
Yes, madam. Thank you.
Any other question? No. Okay, so if there is no other question, we will continue with the other slide. Which is part 2 of the law of tort. if in part 1 we have looked at the 4 elements that need to be proven in order to claim to successfully succeed in a claim of negligence. So for this part 2, we will look at certain things. One, we will look at vicarious liability. So vicarious liability is, as I said before, it is when your employee commits some kind of wrong, and the person who will be sued, usually the one who will be sued is the employer. So either so when a plaintiff sues in negligence, he may name the alleged tortfeasor's employer as a co-defendant. So usually when a plaintiff sues in negligence, he will sue both the employee and the employer. But sometimes there will because vicarious is an exception to the principle, because when you if you remember what we said in the blog, when kind of wrong, you must be a person who have committed a fault. So vicarious liability is an exception to the principle. So even though the employer have not done any wrong, even if what happened is not the fault of his employer, but if it is if the wrongful act, if the tortious act is committed by the employer's employee, so the employer will still be liable. So the principle of vicarious liability says that an employer is liable for the tort committed by his employee in the course of employment. So the employer need not be at fault. So the employer might be innocent, but he will still be vicarious liable due to his position. Still have to pay damages to the victim if the employee is found liable. But vicarious liability, if a worker is negligent or malicious act, even if a worker assault someone or if they commit battery against someone, but in this situation we will only look at negligence. If a worker is negligent and his negligence cause someone to be injured, so under the concept of vicarious liability, the employer is vicariously liable. So the one is liability. So why do we have this vicarious liability concept? The concept of vicarious liability exists because people believe the court, this concept starts in the court. The court believe that the employer has the financial means to bear the cost of compensating tort victims, because as you know, usually employer, they will have insurance to cover their company's liability. So usually the employer will have the financial means to bear the cost of compensating tort victim, because sometimes the worker might not have a lot of money. So if you sue the employee, you might not get as much compensation as you want. So if you want to get more compensation, it is better to take action against the employer, because the employer has the financial means to bear the cost of compensating the tort victim. And then that is one. The second reason is because an employer that has been found liable for an employee's tort will take measure to increase of safety. So if the employer know employee is not so trained, is not well trained, so the employer will take measures to increase the standard of safety, because no employers want to be sued twice by their clients. So by liability, they will take measures to increase the standard of safety. And the other one is what I said before this, because the employer is the one who has the benefit of insurance, so they have more money to pay to the tort victims. So these are the reasons why we have the concept of liability. So the next question is how to impose vicarious liability. Can you impose vicarious liability towards all employers? In order to impose vicarious liability on the employer, there are three requirements that have to be fulfilled. So there are three conditions, three criteria, three elements that you have to prove before you can say that the employer is vicariously liable towards the wrong committed by the employee. So the first element is the simple one. The first element is there must be a wrongful act. So before you can say that the employer is liable for an employee's tortious act, first it must be proven that a tort has been committed. So before you go under the issue of whether the employee have to pay or not, first you have to the four elements of a tort has been committed. So you have to go through the first class during the second topic. So the court have to decide whether a tort has been committed. So they have to go through all this: duty of care, breach of duty, causation of damage, remoteness of damage. So once the court has decided yes, the tort has been committed, so it is proven the employee does commit some act. The employee have committed some act, some tortious act, and a tort has been committed. So once the court has decided that a tort has been committed, two more requirements have to be fulfilled. The first one, in order to make the employer liable, first you must prove a special relationship between the employer and the employee. So first you have to prove that the tort is committed by an employee, because under the law there are two different types of employee. The first one is an employee under a contract of service. Another one is an employee under a contract for service. So under the law, if you are a worker who is under a contract of service, you are considered an employee. A worker who is under a contract for service, you are not an employee, but you are called an independent contractor. So vicarious liability only applicable for a person who is an employee. So it is only applicable for a person who is under a contract of service, not for a worker who is under a contract for service. So that is the second element. You have to prove that the tort is committed by an employee. So later we will see what do you mean by an employee, how to prove that someone is an employee. And then the third element is you also have to prove that the tort is committed within the course of employment. So you also must you also have to prove that the tort happened when he is doing his work, when he is working. That is the third element. So once you prove all these three elements of vicarious liability, then you can say that the employer is liable for the wrongful act committed by the employee. So we will see the second and the third requirement one by one. First, the special relation requirement. So we first have to determine who is an employee. Siapakah seorang pekerja? So an employer is only vicariously liable for the negligence that is committed by his employee under a contract of service. So if the tortious act is committed by someone who is under a contract of service, the employer will be vicariously liable. But if the tortious act is committed by someone who is an independent contractor, so he is not under a contract of service, but he is under a contract for service. So in that situation, the employer will not be vicariously liable. So how to distinguish between an employee and an independent contractor? So there are three tests which may be used. Nature of relationship between an employer and his employee. So there are three tests. You have to remember all three tests because if this comes to exam, so you have to determine which test to be used to know whether the employee is an employee or not an employee. So the first test is the control test. So the control test is the simplest test. So under the control test, it states that if the employer has the power to instruct the employee. So if the employer has the power to tell the employee what to do, and the employer have the power to tell the employee how to do it, so he can control the method in which the work has to be done. So it means that the employer has the power to tell the employee what to do and how to do it. So in that situation, it is clear there is a contract of service between them. However, this is only relevant for contract of service involving labor worker. For example, someone who is working at a construction site, or someone who is working as a domestic worker. That kind of employee, yes, you can tell them what to do and how to do it. However, many modern employment cannot be analyzed using the traditional control test anymore. So, for example, if you are employed as a professional, for example, you are employed as a doctor, or you are employed as a nurse, or you are employed as a lawyer, or you are employed as a someone who is professionally trained. In that situation, usually the employer does not tell the employee how to do his job, because sometimes and many times the employee knows how to do his job even better than the employer. So in that situation, the employer will not tell the employee how to do his work. But in this kind of situation, in this kind of profession, for when the workers are professionally trained workers, you don't have to tell the workers what to do and how to do it, but general control is sufficient. If you want to use the control test, general control is sufficient to analyze the relationship between them, whether it is a relationship of an employer or an employee or not. For example, a doctor is still an employee if the doctor's salary is paid by the employer. So if the doctor get monthly salary from the employer, he is still an employee, even though the employer does not. Okay, so every day you have to, every week you have to complete. I'm just giving example. For example, every week you have to complete 70 hours of working every week. So every week you have to finish 70 hours of working, and in a month you have, there is that kind of rules. So you have a rules on your working hours, or you have a rules on your salary. If there is that kind of rules, it can be said that there exists a relationship between an employer and the employee. So if you can tell someone how much are they going to be paid, and you can instruct someone to work from 9 to 5 every day, or you can instruct someone that that situation is the person is your employee. So in that situation, the person is an employee under the control test, even though you did not tell the employee how to do their work. So that is the first test, the simplest one, control test. And then if the control test is not applicable, you can try the second test. So the second test is what we call organization or integration test. So under this test, what you have to determine is whether the work that a person performs is an integral or essential part of the organization. So how important is your work? So if you are an employee, whatever you do, it is integral to the business. So it is important to the business. But if you are an independent contractor's job, if you are an independent contractor, what you do is important to the business, but it is not part of the business central activities. So, for example, between these two workers in an accounting firm, who are an employee between these two? Accountant
Accountant. Accountant.
or the office cleaner? Who are the employee?
Accountant.
Why? Why the accountant? Why not the
Madam, education background.
That is one. Other reasons why the
Because
accountant?
the accountant is
Oh,
important,
madam, qualification.
Sekejap. Abdul Hadi dulu. Apa dia?
important to the business.
Yes.
Meanwhile,
Saraj?
the
Um,
cleaner is part of the business.
Qualification, madam. They are qualified to be in that job position.
Qualification. Hadi
Uh,
said important to the business.
Madam,
Can I add, madam?
Syakila pula. Sekejap. Syakila, yes.
because the company needs more the accountant punya part than the cleaner punya part.
Okay. Anyone
Okay.
else?
Can I add on? Okay. Maybe because to the business, they need the accountant more, like Shakila said, because this business still can run without the cleaner. So the accountant are more responsible as an employee.
Yes. Yes. So your answer correct. Between an accountant and a cleaner, this is because this is an accounting firm. Because it is an accounting firm, an accountant is an employee. Not an employee of accounting firm. Why? Because as you all mentioned before, an accountant is an employee because in the accounting firm, what he did, his work as an accountant is a very important part in the business. It's an integral role to the business. So the accountant, yes, he is an employee, like what you said, because if he did not do his job, the company cannot run and they will not get any profit. But if you are only a cleaner who cleans the office every day, usually you are only an independent contractor because cleaning is not integral to the business. So the firm can still operate without being clean. So that's the difference between an employee and an independent worker if you use the organization or integration test. So if you are a worker who is important to the business, what you did is important for the business. If you did not do your work, the company cannot run or the company will lose profit, then you are integral to the business. But if you what you are doing is not central to the business, I mean if you do your work, the company can still run. For example, a cleaner, even if the cleaner does not come to the office can still run. You are not an employee, so you are just a contract. You are just an independent contractor. Okay, so this is for the second test. And then the third test is if you cannot use the first test, the control test cannot be used, and the organization test also cannot be used. So the third test is what we call multiple test. So in this multiple test, the court use their common sense approach, and they look at a combination of factor. So for multiple tests, you have to see their contract, the contract which is signed between the employer and the employee. So if the contract state that the employee agrees to use his expertise for a company's benefit in return for remuneration. So meaning that the employee agree that I work for you and you will pay me salary. So that is the first factor. The second one, he also agreed to be bound by the company's rules or the employee's instruction. So he will follow the company rule. If the company asks him to come into the office every day from 9 to 5, ask him to do something, he will do it. And then there are other conditions in the agreement which are consistent with the nature of the job being a contract of service situation. The employee will be the worker will be considered an employee, not a independent contractor. So second test doesn't work. Then you can use the third test. But in Malaysia, the third test is not very used. It's not used much because in Malaysia you have to see. You have to see the contract of service. You have to read the contract of service and see whether all the terms in the contract of service for service. And then you can also consider some other factors. For example, if you are paid in lump sum, kerja dapat bayaran. Habis kerja dapat bayaran. If you are paid in lump sum, then you are considered a independent contractor. Tak paid salary every month, then you are an employee. So for example, a freelance person is only an independent contractor. Or for example, when you run a company and you ask the IT person to come and check your network system, or you ask the IT person to come maybe once a month, because once they finish their job, you will pay them according to your invoice. That person is not an employee. That person is only an independent contractor. And then, but if you do not use the tools provided by the company, and you are only entitled to salary, so you are an employee. So these are some of the other factors that you can use to determine whether someone is an employee or an independent contractor. Why is it important to differentiate between an employee and independent contractor? Is because the employer is only liable for vicarious liability if it is his employee. If the person who commits the wrong is an independent contractor, the employer will not be liable for under vicarious liability. So that is the second requirement to determine whether an employer have liability under have vicarious liability or not. So any question about who? Any question about the three tests? Okay, so if there is no question about the three tests, we'll continue with the third requirement. So the third requirement is the employee must, if the tortious act is committed when the employee is doing what he's employed to do. So if the employee is doing his job, when he committed the wrong, he is considered to be in the course of employment. So the first one is you have to see the closeness between the careless act and the employee's job. The employee is doing his job, it is considered to have occurred in the course of employment. For example, in this case, the Century Insurance Co Limited versus Northern Ireland Road Transport Board. In this case, an oil tanker driver delivered petrol to a petrol station. So this is a case involving an oil tanker driver. So he is in the way on the way to deliver petrol to a petrol station. So when while the petrol was being transferred from the lorry to the underground underground garage, the driver lit up a cigarette. So he lit up a rokok cigarette and he threw the match on the floor. So the match caused explosion, and the explosion destroyed the petrol station. So in this, the court held that the driver's negligence occurred in the course of employment, because even though it is his fault, he is the one who lit up a cigarette and he is the one who threw the burning match, but because he is doing it when he was doing his job, because he was doing his job in delivering the petrol to the petrol station, so the employer is still vicariously liable for the negligence that he has committed. So when in this case, we can see that if the employee is did some kind of mistake, did some kind of wrong when he is doing his job, even though what he is doing is not related to his job, but if he is in the course of his employment, the employer will still be vicariously liable. That is the first one. And then the second one, even if the employee is doing something authorized in an unauthorized way. For example, if the employer or worker commits a mistake in the course of performing his job, the court will still hold the employer liable. For example, in this case of Bailey, in this case, the porter of the train pulled out a passenger from a train. as the porter mistakenly thought that the passenger was on the wrong train. So this is a mistake which is committed solely by the employee. But the court still had the defendants were held liable because even if he is doing even if the mistake is done by himself, but because he is still in the course of doing his work, the employer is still liable for vicarious liability. However, if the employee if the employee is acting for his own benefit, the employer may not be vicariously liable. There are these two cases. One case is Samin bin Hassan against government of Malaysia. In this case, the defendant has driven the company's car back to his house. So he has driven the company's car back to his house, and the accident occurred when he was on the way back to the office. Then he has took the vehicle, the company's car back to his house. He got into an accident with the plaintiff. So the plaintiff was knocked down by the defendant. So at the time when they refer to the logbook state that defendant brought the vehicle out for test to test the brake. But evidence showed that there is no reason to test the brake. So actually the defendant was actually at that time he was taking the car out unauthorized without authorization, because he is lying. Actually there is no need to test the brake, but he said that he take it out just to test the brake. He's actually unauthorized in using it, maybe because I don't know, for some reason maybe he wants to borrow the company car to bring it back to his house. Anyway, he was not doing something authorized. So he's not authorized to take out the car at that time, but he take out the car and accident happened. So in this situation, the court state that because the employee is acting for his own benefit, the company is not vicariously liable. So the company is not liable to pay damages to the plaintiff who was knocked down by the defendant. But there is this other case, one case. In this case, the defendant was a driver. So defendant was a driver. He was to go from one place to another. So when the accident happened, he had just dropped his employer at one place, and he is on the way to go back home to have his lunch. So he wants to go back home and have his lunch, and then return back to the office to fetch his employer back. But on the way, he got into an accident. But in the court, because he is still doing his job, because he just dropped off the employer and he was going back home to have lunch for a while before he go back to fetch his employer back. In that situation, he is still said to be doing his job in the course of employment. So in that case, the defendant was held, so his employer is held liable for vicarious liability. So the difference between these two cases is, in this case, he was not authorized to use that car, but he still use it. So the company is not vicariously liable. But in the other case, because he is authorized in using that car, and he just in the midst of having a lunch for a while before he continue to do his job, it is considered that it is the wrong is committed in the course of employment. So is the third element for vicarious liability. So if you can prove all these three elements, the element of the tort has been committed, and the one who committed the wrong is an employee, and the wrong is committed in the course of employment, the employer will be vicariously liable for any wrongful act committed by the employee. So that is vicarious liability. Any question about vicarious liability? No. So if there is, yes.
No, madam. I was about to say no.
Okay.
Thank
So
you.
if there is no question, We'll continue with the last part of topic 3 and also the last part of law of tort. So there are some general defenses under tort. So when I said about defenses, it means that even though you have committed the wrong. So, for example, in the tort of negligence, all the 4 elements have been proven. So you are liable for negligence, but there are certain defenses that a defendant can use to protect himself. So when he invoke one of these defenses, some of the defenses can absolve him from blame. Means that some of the defenses can make him not liable to pay at all. But some of the defenses can only reduce his liability, so he only have to pay less. Contributory negligence, contributory negligence, usually it will only reduce the amount of claim. So, for example, if the plaintiff might supposed to get 150,000 ringgit, but if the court found the plaintiff has contributed to the negligence, so the plaintiff has contributed to his injury, the court may reduce the amount of claim. Maybe he will not get the 150,000, maybe he only get 100,000. So that is the purpose of contributory negligence. So contributory negligence means that the plaintiff has failed to use reasonable care for the safety of himself or his property, which then gives rise to his damage or injury. So basically, contributory negligence means that yes, someone has committed negligence against you, but you also, as a plaintiff, you also have a duty to take care of yourself. But because you don't take care of yourself, you don't take any action to reduce your damage, that's why you get that much damage. So that is the gist of contributory negligence. So contributory negligence is a partial defense. Partial defense that means that it reduces the amount of compensation. It doesn't extinguish the liability, the whole liability. So it reduces the amount of compensation payable to the plaintiff in proportion to his own contribution. So when the defendant plead that the plaintiff also contributed to the negligence, the court will see how much is the liability of the plaintiff. So if the court has properly determined the amount of contributory of the amount of contribution of the plaintiff which caused his damage, it will reduce the amount of compensation accordingly. So for contributory negligence to be a proper defense, the defendant must plead contributory negligence of the plaintiff. So it means that when the plaintiff sue the defendant at the court, the defendant must inform the court that the plaintiff has also contributed to his negligence. So the contributory negligence must be plead. How to explain about pleading? Okay, let me try to explain it simply. When a plaintiff want to take action against a defendant, the plaintiff will file this thing that we call okay. So when a plaintiff wants to sue a defendant, first, I'll just tell you generally about the procedure involved. So when a plaintiff wants to take action against a defendant, first he will issue what we call a letter of demand. So the letter of demand will state that the defendant has committed some wrong, blah blah blah, and because of this wrong, the plaintiff wants to take action against the defendant. So after he has issued the letter of demand, he will file in the court. He will file this what we call writ of summons and statement of claim. So he must file a writ of summons and statement of claim, and inside the statement of claim, he has to state all his allegation. He has to state that he wants to sue the defendant for negligence because of whatever the fact. So he have to put everything inside his statement of claim. So as a defendant, when a plaintiff has served a writ of summons and statement of claim against you, what you have to do is you have to reply to the statement of claim. So this is what we call a statement of defense. So you have to file a statement of defense stating your side of the story lah. So you have to tell your side of the story in your statement of defense. And at the same time, if you want to claim something against the plaintiff, you must also file something which is called a counterclaim. Okay, so in general, the plaintiff will serve you a writ of summons and statement of claim. So as a defendant, you have to file your statement of defense to defend yourself, and at the same time, you have to file a counterclaim if you want to claim something against the plaintiff. So in this case, when it states that a defendant must plead contributory negligence, if the defendant can see that the plaintiff has also contributed to the negligence, the defendant must file a counterclaim. So in the counterclaim, it must state that I want to claim against the plaintiff for contributory negligence. That is what it means by pleading. File a claim against the plaintiff stating that the plaintiff also contributed to the negligence. So that is how the case in the court starts. So after counterclaim, you don't have to know lah. So after the counterclaim, if there is no other claim, they will close the pleading and will start the hearing. So basically, you just have to know that if you want to use contributory negligence, if you want to use the defense of contributory negligence, it must be plead. So you must inform the court beforehand, before the hearing, that the plaintiff has also contributed to the negligence. So that's why I state here. Yes. So it basically the defendant is basically saying that yes, I am negligent, but you also contributed to the injury that you suffer. So I want to so the defendant is saying that he has committed some wrong. He has committed negligence, but the plaintiff also has contributed to the negligence. So the plaintiff should also take some responsibility for his actions, something like that. Yeah, in simple words, you can use what Shakila said. Plaintiff is also part of the negligence. So basically, he is saying that yes, but you also did something wrong, so you have to bear some of the consequences. It's something like that for contributory negligence. Okay. So when I say that you must plead contributory negligence, so in this earlier stage before the hearing, you have to tell the court that the plaintiff has contributed to his negligence, to the negligence. Because if you did not inform the court before the hearing that the plaintiff has contributed to the negligence, it will be fatal to the defendant's case. It means that if you did not tell the court beforehand that the plaintiff has contributed to the negligence, you cannot raise the defense of contributing negligence later in the hearing. So you see what I mean? So it means that if you want to use contributory negligence, you can, but you have to inform the court beforehand. You must inform the court at the early stage. You cannot raise this defense during the hearing. You have to inform the court earlier that the plaintiff also contributed to the negligence. Okay, so under Section 12 of the Civil Law Act 1956, the Civil Law Act did state that if a person suffer damage as a result partly of his own fault and partly of the fault of any other person, his claim shall not be defeated by the reason of the fault. So it means that even if you still have it means that even you have some part in that wrong, you still can claim damage, but the damages you can recover will be reduced. So basically, Section 12, subsection 1 of the Civil Law Act allows the claim for contributory negligence. Okay, so there are 3 elements of contributory negligence. The first element is the plaintiff duty of care upon himself to act reasonably so as to avoid damage to himself. So in contributory negligence, the plaintiff does not have to prove that he has the duty of care upon the defendant, but you only have to prove that he has a duty of care to protect himself. He have a duty of care to act reasonably, because everyone also have the responsibility to take care of yourself. So that is the first element. You have a duty to act reasonably because you have to avoid damage to yourself. And then the second element is he has failed to take reasonable care of himself because he has behaved unreasonably, and that act or omission has caused his injury. So for contributory negligence, you only have to prove that the plaintiff have a duty to take care of himself, and he's failed to take care of himself. And because he failed to take care of himself, injury happens. So I think if you see cases, it will be clearer. Okay, so for example, in this case, the case of Jones against Livox Quarries Limited. In this case, the employer has clearly instruct all his employees. So track excavator is this vehicle slide. Track excavator is, I'm not sure what is it called, tapi that kind of lorry yang korek tanah tu. So a track excavator. So the employer has instruct all the employees, you cannot ride at the back of a track excavator. But in this situation, the plaintiff does not listen to the instruction. The plaintiff disobey his employer's instruction, and he so another vehicle hit the back of the track excavator. So when the track excavator is trying to change his gear, another victim hit the back of the track excavator. So when the another vehicle hit the back of the track excavator, the plaintiff fell and he was injured. So in this situation, the court held that the plaintiff is guilty of contributory negligence. So the court said that yes, the other lorry has committed a negligent act by hitting the back of the track excavator and causing the plaintiff to be injured. But the plaintiff is also guilty of contributory negligence because the plaintiff knows that if he ride at the back of the track excavator, it is very dangerous. And if you ride at the back of the track excavator, if something happened, for example, if another vehicle hit the back of the track excavator, you can fall and you can be injured. So in this situation, the court said that he ought to have foreseen that he did not act as a reasonable man. The employer has stated clearly, you cannot do it, but you still do it. So you are being unreasonable. You did not take care of yourself. So when you did not take care of yourself, you have gotten hurt. So once contributory negligence is proved, the person guilty of it must bear the proper share of responsibility for the consequences. So in this case, the court stated that the plaintiff suffered damage as a result partly of his own fault. So it said that even though it is a negligence of the other vehicle also contribute to the negligence, you will get some compensation, but you will have to share some kind of responsibility to. Compensation will be reduced, if I'm not mistaken, of the negligence act. So the fourth 405 of the compensation, because it states that he has contributed to the negligence. So this is the case of Jones. And another case is the case of Ramachandran, anak lelaki Mayandi against Abdul Rahman bin Ambo and another. In this case, plaintiff requested by another employee another employee to open the door so that trailer, and the plaintiff was asked to open the door of the trailer. So he did not take any precaution. He just flung open the door, and a few pieces of iron rod rolled. He was injured. So in this case, the court held that the plaintiff has contributed to his negligence. Has contributed to the negligence because one, he failed to stand at a safe distance when removing the pin of the trailer door. So he is not supposed to stand too near to the trailer door. He is supposed to stand at a safe distance. And failed to consider that and there is some risk that the iron rods will roll down once the door was opened. And then he also failed to assess the risk, although he knew that danger will be created by his act. So basically, in this case, the court state that the employer is wrong by not tying the rods properly, but you also contributed to the negligence by not standing at a safe distance and by not in contributory negligence, you can claim for the negligence of another person, but if you did not take sufficient care of yourself, you did something wrong, you are not acting, you are acting unreasonably, you can still be partly liable for the negligence. So that is what we call negligence. So you will still get your compensation, but your compensation will be lessened according to how much contributory is how much had you contributed to the negligence. So that is the first defense, the defense of contributory negligence. You have about this defense? Negligence.
No, ma'am.
Okay. So if everyone is clear about contributory negligence, we will continue with the second defense under tort law. This Latin word, which is voluntary non-fit injuria. Voluntary non-fit injuria is a Latin maxim. In law, we have a lot of Latin maxim, and this is one of them. So it is based on a Latin maxim, which means that to cannot be considered an injury. So it means that if a person has consented to something and he suffered injury due to his consent, he cannot claim for negligence. So if a plaintiff has consented or voluntarily assumed, he cannot claim damages if the injury occurs. So for voluntary non-fit injuria, the defendant have to prove that first the plaintiff has consented to the risk of injury. So the simplest and clearest way to see whether a plaintiff has consented to the risk of injury is when a plaintiff has signed a consent form. Okay, so if a plaintiff has signed a consent form, second one, the defendant must also sign mati. Sign mati tu macam mana dia macam for example lah, when you are doing some kind of extreme sport. For example, when you are doing bungee, stating that I declare that I am of good health. I declare that I am of good health and not be responsible for any injury. And yes, for sports also, if it is a sports with very high risk of injury, for example, the sports of boxing or martial arts, that kind of sports, the defendant can also invoke this defense of voluntary non-fit injuria, because when you choose to participate in this kind of brutal sports, this sports, boxing and martial arts, you have assumed the risk of injury by joining that sport. So that also can fall under the first requirement. Yeah, like occupation like offshore also. You to you consent that when you are working in the middle of the sea, some kind of would be this. If you want to undergo some kind of surgery, is it still lagging? Is it clear or is it still lagging? Yeah, bad network quality then. If I leave and join it back, is it still lagging or is it okay now? Because my line is sometimes quite tengah ni lah. Bad network quality. Okay. Okay, so if you are a safety supervisor, what do you mean by safety supervisor? Sharin, what do you mean by safety? Okay, so you mean that if he is a supervisor, he is a safety supervisor, and it is a risk that when they are doing their job, they will come across some kind of injury. Yes. If your line of work is kind of a dangerous work, so you are doing some kind of your work is a dangerous type of job. Yeah, you can say that have voluntarily assumed the risk of injury. So if the injury does occur, and it means that when we talk about injury, we are talking about the normal type of injury that happens because of the nature of your job. Yes, the defendant can invoke this defense. Talking about this normal risk of injury tau. If the injury that happens to you, even in a dangerous type of job, but if the injury occurs but the injury occurs because your employer is grossly negligent, your employer is doing something very wrong, so in that situation you still can claim. But if the injury that occurs is the normal type of injury which fits the nature of your job, then the defendant can invoke this defense of voluntary non-fit injuria. Okay, what I said, usually this is relevant for cases involving sports. So if you're a sports person, it can be said that because of your nature of your job, you has consented or voluntarily assumed to some risk of injury. So if the injury is a normal type of injury, yes, the defendant can use this defense of voluntary non-fit injury. But if the injury is excessive or if the risk is too high, then they still cannot use this. So in order to invoke this defense, first, there must be some kind of consent from the plaintiff. And the second, the consent must be voluntary. So you cannot force someone to consent. Yes, yeah. It's like surat lepas tanggungjawab, or in Malay, in English, we call it waiver form. Waiver form or indemnity form. Yeah, that kind of letter is also used for this voluntary non-fit injury defense.
Excuse me, madam.
Yes.
Those waiver forms are usually signed at an event where the job is usually life-threatening, right, madam? Like
Yes. If there is some risk that some
welders that have to work under high pressures underwater in it's like something like that, kind of, madam.
Yes.
Okay, understand a little bit. Thank you.
Okay. Yeah, Hadi. Also, when you sign a form before an operation is conducted by the hospital, that one can also falls under this defense. If you sign the form, it can be said that you consent to the risk of injury. But even if you sign the form, the doctor still have to prove that they did their job properly. If there is no negligence, if there is no negligence on the part of the doctor has done everything he has to do properly, and then you has consented to the risk of injury, and something happened after the injury, after the surgery, you cannot take any action against the doctor because the doctor can invoke this defense of voluntary non-fit injury. Okay, so the first one is you have consent to the risk of injury. The second one, the consent must be voluntary. You cannot be forced to sign the consent form. And then the third one is the plaintiff must have full knowledge of the nature and extent of the risk of injury. So you must know what you are signing for. Okay, so for example, in this case of Woolrich against Sumner, the plaintiff was a spectator, come photographer in a horse racing competition. So during the competition, one of the horses skidded. So the horses, one of the horses skidded, and it caused some kind of injury. Defendant was not liable as he had taken reasonable precautions and has discharged his duty satisfactorily. In this case, the court said that defendant has done everything that he has to do to make sure that the horse racing competition is safe. So, a spectator of a game is assumed to have taken the risk of injury to himself as a result of the action of the players. So, this is similar to when, for example, in a sports of football, when you are watching football in the stadium, as a spectator, maybe some of the footballer has ball too high and then the ball go above the goal post and it injured one of the spectators who are in the stadium, for example, in that kind of situation. In that kind of situation, the person who is injured by the action of the footballer cannot claim under negligence because the defendant can use this defense of voluntary non-fit injury because you choose to be spectators in that football stadium, so you are assumed to have taken the risk of injury to himself as the result of the actions of the. As long as the football stadium can prove that there is no wrong, there is no wrong on their part, so they have done all the reasonable precautions, but it still happens, you still got injured, you cannot claim. Okay, so that is for the case of Woolrich, and this is also this is for the for sports. In the case of Gilmore against London County Council, in this case, the plaintiff was a member of physical training class run by defendants. So during one session, when they were lunging at one another, the plaintiff lost his balance. The plaintiff lost his balance and he injured himself. So in this case, the plaintiff slipped on the floor. The floor was slippery, and the plaintiff slipped on the floor and he fall, so he injured himself. So in this case, the court held that sustained injuries as a if the plaintiff sustained injuries while if the plaintiff sustained injuries while doing the sport, while undergoing the physical training class, then he cannot claim, because it can be said that he has consented to the risk of injury because he choose to participate in the sport. But in this situation, because uh, the reason he fall is due to the slippery floor, he did not consented to work on it to do exercise on the slippery floor. So because of the reason of the slippery floor, the court cannot use the defense of voluntary non-fit injuria. So you see the difference. So if it is something you agree, if it is something you assume the risk for, you cannot claim. But if it is something that you have not consented to, it is something that you have not assume the risk for, you still can claim for voluntary non-fit injuria. Okay, so that is voluntary non-fit injuria. Okay, I just finished the last one. So the last one is inevitable accident. So defense of inevitable accidents requires the defendant to prove that the cause of the accident and the result is inevitable. So in inevitable accident, you can use this defense if you have done everything. You have done all the precautions as a reasonable man, and what happened is beyond your control. So even if you have exercised the highest level of skill, the highest level of care, it still happens. For example, you have tried your best to repair a vehicle, and when you test the vehicle is running smoothly. But then 1 week later, something happened to the vehicle, and it is actually caused by a latent defect that even if you check before this, you will not realize it. So in this kind of situation, you can use the defense of inevitable accident, and you can use it to say that you are not liable to pay for compensation because an accident. This is something inevitable. I have done everything I could, but it still happens. So that is the third this negligence. Okay, so any question vicarious liability or any question regarding I am so sorry because my network today sometimes it got bad network quality, but you don't have to worry. Once this class ends, I will once the recording is ready, I will upload it on my YouTube channel, so you can refer to the YouTube channel. So once I upload on the YouTube channel, I will share the link. I will share the link with your in your class in your virtual website. Okay, so if there is no other question, can we end the morning session? For
Yes.
those who joined the class, okay, so for those who joined the class late today, in the beginning, for the evening class, there will be two different sections. There will be section 2 and section 3. So students who are in section 2, you will have your tutorial class this evening. So your class will start at 2:30. You will have your class with me. There are 27 of you who is under my list. So yeah, we will do our tutorial together. Yeah. So we'll do our tutorial together this evening. I have some questions I will upload, and I do have 1 or 2 activities to do with you. And the other 25 students, you are doing your tutorial with Miss Fatin. So if you open your UNIC virtual website, she already shared your link. So for the class in the you can refer. You can go. You can join her class. Desiman, I already shared the slide. Yes, I already shared the slide in UNIEC virtual website. So you can download the slides from there, both the topic 2 and topic 3. Okay, if there is no other question, okay, it's okay. So if there is yeah, because the assignment and presentation, yeah, the assignment and the presentation will be conducted and marked by two different lecturers. So for the students who are under my tutorial groups, I will conduct your presentation and I will mark your assignment. So in the evening, we will discuss I will explain to you on the assignment question during our evening class. But for those who are under the tutorial class of Miss Fatin, your assignment and your presentation will be conducted and marked by her. So if you want to form your group, you have to form your group according to your section. So students from section 2, you have to form a group with another person with in section 2, and for those who in section 3, you have to form a presentation group with people who are in section 3. Okay, so for my class, I will discuss the question for the assignment this evening. Okay, so if you don't have any other question, that's all for the morning session. Our evening class will start at 2:30, and in the evening we will discuss on our assignment question, our presentation, and then we will do some kind of tutorial exercise related to this morning's class. Okay, so if there is no other question, that's all for this session. Thank you.
Thank you, Miss.
Thank you, Miss. Thank you, Miss.
Thank you, ma'am.
Miss.
Terima kasih.